Welcome, and I welcome all of you to work through the rules with me here because it's a little bit of uncharted territory, and I think it's going to take all of us, the judges, judiciary, lawyers, all of us to really work through some of these rules and see where we end up. So I've been asked today to give the keynote, which makes me laugh. I have all these judges and I'm giving a keynote. I mean, I shouldn't be doing this. They know more than I do, but I'll call them out as we go along. But to give a keynote on the new amendments to the Massachusetts Rules of Civil Procedure, and I feel like it's a little bit back to the future. It's almost, exactly 7 years since we've had the federal rule amendments, e-discovery federal rule amendments. So there are going to be a lot of similarities in the state rules we're going to talk about, and I'm going to make an assumption, which I probably should never do, but I'm going to do it anyway, which is since we've had the federal rules around for 7 years, that most of the practitioners here have some familiarity with the federal rules. I'm not going to start from the beginning. I'm going to sort of assume we understand how the federal rules work and compare them to the state rules. So let's give a little bit of context. The 06 federal e-discovery amendments had a few goals. Early attention to e-discovery issues, I think it succeeded. I think we now give early attention to e-discovery issues, at least in federal court. Better management of e-discovery, that's up for debate. Process of asserting privilege after production, yes, that's true, and we'll talk about that. Clarity and clarify applicability of interrogatory and request production of documents to e-discovery. That's really the key to all this, and I think we're going to see this in the state rules. I think the one thing we've all learned is, yes, e-discovery is part of the process. It's the norm. That was the key to the 2006 amendments. And then also clarify the application of sanctions to e-discovery, and we just heard a little bit about that from our panel. Here are our Massachusetts subcommittee members. It's a sterling cast. Know them, love them. This is who they are. If you don't like the rules, you can blame them. You do not have to blame me. Just leave Chris Burek alone. It's not her fault. That's what I'll end with that piece there. And lastly, just talking about some law reform organizations. We threw this up there because there was a conference of Chief Justices guidelines issued in 2006. We knew the federal rule changes were coming. State rules were a whole different ballgame. Question though, and raise your hand. Do people know that prior to now, we've had Massachusetts guidelines for e-discovery? Anyone familiar with those? 2, 4, maybe 5 people in the entire room. I've always been amazed. My partners and colleagues would say to me, do we have anything in Massachusetts? And we did have guidelines. There were published guidelines for e-discovery. They were very vague, they're very amorphous. They really didn't do anything, but we had them. And so, that came out of these guidelines that a lot of the Chief Justices were issuing. And today, and starting next month, we take a much bigger step. We go from our guidelines to real codified rules of civil procedure, sort of where the feds were in 06. So what's changing, and what do you need to know as a practicing lawyer in Massachusetts? Well, we have 5 major changes to Rule 16, to Rule 26, 34, 37, and 45. And we're going to go through them. I'll explain them. I know you've gotten a little bit of this in pieces and chunks through some of the panels, but I'll try to put it together in a more comprehensive format for you. First of all, let's talk about Rule 16. First of all, another question. State court, not federal. How many have ever been to a Rule 16 conference in state court? Wow, it's actually more than I would have thought. You don't get one. There's not one as a matter of right. My old mentor taught me that when you can't get what you want, you should just file a motion for a Rule 16 conference. And you end up in court and a judge would listen to you. So I tend to use Rule 16, but most state court practitioners do not. And that may very well change with the rules, which are focused on e-discovery, but may force us a little bit more into the federal model of appearing for a Rule 16 conference. And what are we dealing with? We're dealing with the timing and extent of discovery, of course. We're dealing with the preservation of evidence, which I'm going to talk about. And we're dealing with agreements like we have in federal court regarding claims of privilege and protection and everything else. So Rule 16 is changing, and we're going to talk about that. Then we're going to have the changes to Rule 26. I'm going to discuss this in a bit, but as a practical matter, we start to look a lot like federal Rule 26 with a huge difference in my mind. And think of it as a contextual difference. I think, I can't remember which panelists talked about, in Massachusetts we don't want to be ordered, we want to confer, we want to feel good about it and do it voluntarily. The Mass Rule 26 will differ from Federal Rule 26 in that we have plans, we don't have orders. We have conferences instead of orders. So a lot of this process is really going to be driven by the attorneys and by yourselves, and then only endorsed by the court if and when you are then ready. You can still force the court to enter an order just like you could before, but the process doesn't assume the court imposing an order. The process assumes counsel working together, coming up with a plan, and then having the court endorse the plan. So keep that contextual difference in mind as we discuss some of the specific rules. What are these new provisions? Well, this is probably the key one. This is now Rule 26 F2A, which is you have an ESI conference by right if you so choose. And this is critical whether you're, regardless of which side of the V you're on and whether you want to deal with e-discovery issues or not. Upon the written request of either party, made no later than 90 days after service of the first response of the pleading by any defendant, the party shall confer regarding electronically stored information. So what does that mean? That means if I'm a party that has an interest in ESI, that I know ESI issues are going to drive my case, that I want to talk to opposing counsel at ESI and have court involvement, all I have to do is submit a written request to the other side no later than 90 days after the first response of pleading. I have 3 months, essentially, after an answer is filed to request an ESI conference. And once I request it, it's required, okay? In a minute, we're going to talk about what happens when you don't request it, which is nothing, but you have to request it. By comparison, the federal rules require the conference no matter what. So we talk in Massachusetts and a lot of state courts, parties sometimes like to stick their heads in the sand when it comes to e-discovery. You know, they want to be ostriches, they don't want to deal with ESI. You still sort of have that ability in Massachusetts, even post rules, because if I don't request the conference and my adversary doesn't request the conference, well, there's probably not going to be a conference, right? So there is still a lot of control of the process by the lawyers, but at least there is a way now to force the issue. And you have to do it within 3 months, essentially, of an answer being filed. Now, what happens if you don't do that? Well, if you don't do it within the 90 days, the only way to force a conference is a conference by agreement. So after 90 days, any party may serve on the other a request for a conference, and it shall not be filed to the court. If within 30 days after the request, the parties do not agree to confer, then you can file a motion for a Rule 16 conference on ESI. If you think about it, that's really no different than what we had today, right? If there's no automatic anything, I can always say to the side, I want to confer with you about ESI. If they say no, I don't want to do it, well, then I could have always filed a motion for a Rule 16 conference and said, Judge, I have some unique discovery issues. I want to talk about them. Okay, so it really has to start with one of the lawyers sending out a request for an ESI conference within those 90 days after the filing of an answer. What's the purpose of this conference? Well, the purpose of the conference is to discuss ESI. So within 14 days after the conference, the parties shall file with the court a plan and a statement concerning any issues upon which the parties cannot agree. So if we have a legitimate conference, meaning I've requested one within 90 days of an answer being filed, or we've agreed to have one, even if it's outside the 90-day window, then the parties have an obligation to put together a plan and a statement concerning the issues and to file that and submit that to the court. That's very similar, and I'll talk about this in a moment, that's very similar to the filing we make in federal court under Rule 16 and 26. Okay, so you sort of only get to the federal process if you jump through all those hoops first. You have to you have to request a conference within the 90 days. You have to have the conference. You have to agree on a plan and a statement of any issues you can't agree, and then you submit it to the court. So at that point, we're sort of in the federal mindset. Now we're going to be in front of a judge with a proposal and some disagreement issues, perhaps, that a judge is going to have to rule on. What do we talk about, and what are we going to have the court discuss? Well, these issues are very similar to the federal issues with a few exceptions. Preservation's been mentioned a lot. Yes, we have to discuss preservation. I think that's a good thing. I've been involved in too many cases, as I'm sure you all have been as well, where preservation isn't discussed until 2 years in when someone says, you spoliated all the evidence I expected you to retain. No, you have to talk about preservation if you're going to talk about ESI. You've got to talk about the form in which data will be produced, just like in the federal court. This is that famous metadata piece that we've heard so much about. Took 2 years to get this word metadata into these rules, and I say that jokingly a little bit with the Rules Committee, but it did take 2 years. You know, what metadata, if any, shall be produced? I think that's a tweak on the federal issues, and we'll talk about that a little bit in a bit, but In my view, metadata in federal court is just part of the game. I don't think you can legitimately make the argument these days in federal court that ESI should not include metadata. There is an opening here, arguably in the state court, that metadata shall not be produced, given small, D small III. You have to agree upon the time you're going to produce information, the methods for asserting claims of privilege, whether there's a confidentiality proprietary issue. And I find this interesting, of a party or a person not a party. That last piece is sort of critical. We're all involved in cases where we know there'll be a third party involved. And if you know there's going to be that third party, and you know you're going to be requesting sensitive information by way of a subpoena or something else, you're supposed to talk about it now at the Rule 26 F2D conference. And then allocation of expenses. I'm sure this is going to be a very interesting discussion among most lawyers in the state, but how do we allocate, if we allocate expenses? And then, of course, any other issue that you think is relevant. So this should be your checklist. If you're going to have an ESI conference in Massachusetts State Court after January 1, and these new rules are coming into effect January 1, so we're T-minus whatever, 28 days, then this should be your checklist. The order. Now you've submitted your plan. The court may enter an order governing the discovery of electronically stored information pursuant to any plan referred to above, essentially. Or upon motion of a party or sua sponte after notice. Again, there was nothing stopping anybody today, never mind January 1st, from going into court, requesting a Rule 16 conference, and saying, Judge, I'd like an order regarding ESI. That happens and should happen all the time. All this really does is sort of codify the process to make it a little more formalistic and formulistic, and to make sure the parties understand that if you're going to have these discussions and we're going to issue an order, these are the checklist of things you need to discuss. So we're going to see a lot more ESI orders, obviously, in state court after January 1. Not surprisingly, 26F3 tells us what the order deals with. Wow, the list looks familiar, right? It's the same checklist that you were supposed to do prior to submitting your plan to the court. So I'm not going to read it all again, but it's the exact, basically every item you were supposed to discuss with opposing counsel along the way, now the court is specifically empowered by rule to enter orders on each of those issues. So again, keep your checklist handy, both for your conference with opposing counsel and for the court to enter an order when the time comes. Let's talk a little bit about inaccessible information. This has been a huge issue in federal court. We heard a little bit from the judges just now about how we deal with this. And the new rule says that inaccessible electronically stored information means electronically stored information from sources the party identifies as not reasonably accessible. I believe one of the judges called this a little circular. The word tautology sort of jumps in your head. Inaccessible information is information the party identifies as not accessible. Okay. Because of undue burden or cost, and by the way, the little snarky critiques in brackets, those are mine. Those don't belong to the rules. We would say this inherently syllogistic definition may cause parties to voluntarily define inaccessibility at a dollar number value at the outset of the case. What I mean by that is you're putting the definition of inaccessible information in the hands of the party that's going to produce it. And you're saying that it's inaccessible because of undue burden or cost. Therefore, if you have a dollar limit in mind as to what cost should be, anything above that limit, you're just naturally going to say is inaccessible. So I think we're going to see a lot of fights. This will probably be the big issue that people fight about going forward. What's inaccessible and what factors should go into it? What about other limitations? A party may object to the discovery of inaccessible electronically stored information, and it should specify the reason. And then on a motion to compel, a party claiming inaccessibility bears the burden of showing that it's inaccessible. This is the same as the federal rule. Basically, if I'm going to claim that data is inaccessible for whatever reason, then I bear the burden of showing why it's inaccessible and why it should not be produced. This is separate and apart from, relevance and all the other rules that surround discovery. If I'm going to say, yes, that evidence normally should be produced, but it will not be because it's inaccessible, I bear the burden. That's all that says. It's a procedural burden of proof. I bear the burden if I'm going to claim inaccessibility. And the court can order the discovery of inaccessible information even if the party shows the likely benefits or succeeds outlays the likely burden of its production. And what does it take into account? It takes into account the amount in controversy, the resources of the parties, the importance of the issues, and the importance of the requested discovery in resolving the issues. For those gurus in the federal rules, some of these factors are not in the federal rule. Some of these factors are listed in the reporter's notes to the federal rules, including the resources of the parties. This should make most lawyers in this room who may represent large corporations swallow a little bit, because you have a rule in Massachusetts now that specifically says one of the factors the court will take into account in deciding whether to force you to produce what you've defined as inaccessible evidence is the resources of the parties. Well, you know what, a lot of us have represented large companies. Those large companies don't think they have such great resources. At least the way they go through my bills, they don't seem to have large resources. But the truth is, when you're representing them, the court can take that into account, and probably will. So again, that's a little bit of a checklist about what you might want to do if you're on the plaintiff or defense side and you want information, and the other side is saying it's inaccessible. This is where you attack. The resources of the parties, the amount of controversy, the importance of the issues, and the importance of the requested discovery. Although the court may set conditions under D for the discovery of inaccessible electronically stored information, including the allocation of the expense of discovery. To me, this is a non sequitur. If I'm going to force somebody to produce inaccessible information because I'm so impressed that they have the resources to produce it, I'm then as a judge not going to turn around and put the burden, the cost of that production on the other side, right? That would make absolutely no sense. So if the court is going to make an order based on the resources of the party, that party is going to end up paying the cost of discovery. So D is helpful, but I don't think it's going to change all that much in terms of real practice in the Commonwealth. What else can the court do? The court can limit the frequency or extent of ESI, even from an accessible source, in the interest of justice. By the way, I love when the rules use things like reasonable interest of justice. You know, what is the interest of justice? Whatever lawyers might want to dream up, right? But we have factors, so let's look at the factors. What can a court look to? What factors bear on this decision? And keep in mind now, this is dealing with accessible information. So I haven't made a claim that it's inaccessible. I've just simply said, I don't want to produce it. And a court can still say it does not need to be produced, and here are the factors. Can you obtain the information from another source that's more convenient or less burdensome? Okay, we see that a lot, right? I shouldn't make you tear your backup tapes apart if I can get the information from a third party that has it stored in a readily accessible way. I get that. You know, whether the discovery sought is unreasonably cumulative or duplicative. Okay, if it's the same information that's somewhere else, and it's essentially the same data information, maybe I don't make you tear apart your computer system. Whether the party seeking the discovery has had ample opportunity by discovery in the proceeding to obtain the information sought. Essentially, did you wait too long? Did you just not do it, and now that you want to do it, it's somewhere where it's going to cost more to get? And then lastly, whether the likely burden or expense of the proposed discovery outweighs the likely benefit, burden outweighing benefit. I would suggest that these factors apply to discovery, not electronic discovery. This is the same, you know, I guess we're not supposed to do it anymore, but I just still do it, right? The stock objections, you know, the stock objections to document requests. What's the one we always use? Burdensome, unreasonable, unlikely to lead to the discovery of admissible evidence. This is what this is. This is the exact same thing, only applied to ESI. So if you've been practicing in the state since the 70s at least, you can do this. This is not that difficult. Same factors. Let's talk a little bit, and this is critical, about inadvertent production. And one of the judges made the comment that we have to deal with this because of the volume of information in ESI. And it's true. Why do we worry about inadvertent production in the ESI world and not the other world? Well, I want to give you a little bit of background because we did used to worry about it. And I practiced in the 90s and I practiced in 2000. And Judge Young, pictured there, would literally send fear down the hearts of associates in those days. I don't know if you remember the famous case, and I forget which one this is, the Choate Hall case and others, where he started issuing orders essentially saying you've waived the privilege because a young associate accidentally took a box that was marked privileged and put it in a produce pile. There were these types of issues, and people were scared to death. So we've been dealing with this separate and apart from ESI for years and years and years. But anyway, Judge Young set out what we call the middle test about when and how essentially the privilege is waived because you've produced something you should not have. The key to this, and we're going to talk about this more, and we heard it from the judges, this is substantive law right here. This has nothing to do with the rules of civil procedure. This deals with substantive federal law as to when and how you waive the attorney-client privilege because of an action you voluntarily took. Okay? Nothing to do with procedure. This is all substantive law. We also had the same issues in Massachusetts in the state court, a few famous cases. And the state court has said a client does not lose the benefit of the attorney-client privilege for an otherwise privileged communication through inadvertent disclosure if the client proves that he and his counsel took reasonable steps to preserve the confidentiality of that particular communication. So we've also dealt prior to ESI in Massachusetts state court as to what happens substantively. When is the attorney-client privilege waived? Okay, so we've had a plethora, a whole background of case law in federal and state court, which we still have to deal with because what the committee did, okay, is they took a mix of the federal rule on inadvertent disclosure and a mix of federal rule of evidence 502 on waiver, okay, and tried to put it into the rule. And what the committee notes say is there's nothing in the rule that precludes the party from modifying the procedures set forth, blah, blah, blah. Yeah, the parties obviously can agree. But again, my snarky comments, the impoundment procedures are cumbersome. The new rule permits alternative case-specific protective orders as needed. Well, what is the new rule? Okay, it's a clawback rule. And let's see if we can parse this, because what we were just reading and what we're now reading are two entirely different things. It's a clawback rule that simply says, if information is mistakenly produced, okay, how do you make a claim of privilege? I have produced data to the other side. That data turns out to have emails that have my attorney-client communicate, my attorney advice to my client in the email. Okay, I missed it. I produced it. It's been mistakenly produced. What do? Well, this is very similar to the federal rule in a lot of ways. I have to notify the other party of my oopsie, right? I made a mistake, other party. Don't read that email. It's attorney-client privilege, of course, they're reading the email, but don't look at it. It's privileged, okay? The party making the claim notifies the other party. Okay, done. What does the other party do? They get notice after reading, of course, the email. What do they then do? They shall promptly return after reading, sequester or destroy the specified information and any copies it has. And it shall not use or disclose the information until the claim is resolved. Shall take reasonable steps to retrieve the information if the party disclosed it being notified and may promptly present the information to the court under Trial Court Rule 8. Blah, blah, blah. The producing party shall preserve the information until the claim is resolved. What's the key word there? Yeah, until the claim is resolved. Okay, how do we resolve the claim? Oh, look, there's Judge Young again. That's how we resolve the claim. This rule is just a procedure. This just tells you the steps you take when you've made the mistake. It doesn't tell you that you get it back. And I mean, there's so much misinformation on these rules out there. People think that this is, they call it a clawback. It's a temporary clawback. It's not a clawback that gets you the information back forever. It's a clawback that gets it back temporarily until the court can make a substantive ruling. That's why we heard so much about Federal Rule of Evidence 502 and the state court analogs. That's why you want an order protecting this information. Because if you have an order protecting the information, then this procedure for a clawback becomes binding, so you can take it back and it's not waived. But if you just rely on the rule as a practical matter, you end up with the substantive law determination as to whether it was inadvertently produced and all of that plays into it. And we're not dealing obviously in federal court, but in this case we're dealing in state court. So beware the clawback provisions. They are procedural. They are not necessarily substantive. Okay, in resolving the claim, the court determines whether the disclosure was inadvertent, the holder took reasonable steps to prevent disclosure, and the holder promptly took reasonable steps to rectify the error. This is the piece that matters. This is the substantive piece. But it really is just the same test we were looking at before. Okay, so you still have to show all these elements in order to get the document back for real in order to prevent a subject matter waiver of the attorney-client privilege. What happens upon a ruling? If the court following the procedure upholds a privilege, the disclosure shall not be deemed a waiver in the matter before the court or in any other proceeding. That's great, but again, I would not rely necessarily on this rule because you still have to win the substantive battle. It's a clawback until you can show, as a matter of law, under this rule, that you did not waive the privilege. So keep that in mind. That's a little bit of my bugaboo, so I'll keep stressing it, but that's an important piece of this. What else is changing? What do we need to know? Well, and I'm moving quickly, I know there's a lot here, and I've got limited time. So there's a new Rule 45, subpoena rule, and I throw this out there because I don't think we think about Rule 45 much, but we should. In most cases, we have document subpoenas, we have to take depositions of third parties, and so Rule 45 matters. What's changing? Well, the most important thing that's changing, and this is key, this is changed in the federal rule as well. A party or attorney responsible for issuing and serving a subpoena must take reasonable steps to avoid imposing undue burden or expense on a person subject to the subpoena. We'll see what impact it has on the bar, but I know in federal practice it has changed things a little bit. I know colleagues of mine who are much more careful in issuing Rule 45 subpoenas and document requests to be much more narrow in their requests than they used to be. Not just ask for everything and see what the other side will give you in a third-party context. Also, we tend to have very different definitions of what type of ESI we want produced by way of subpoena as opposed to a party, where the subpoena recipients were much more lenient on. You know, we try to make it as simple as we can in federal court. I think that's going to make its way into state court practice because it's now the burden of the party, the attorney issuing the subpoena, to make sure that there's not undue burden or expense imposed on the third party. So it seems like a minor shift, but it's important to keep in mind, and I think you may see some sanctions orders and other things under Rule 45, because in my experience, judges are much more protective of true third parties to a case than the parties battling it out in court. We adopt obviously the new rule, as I said, the federal rule. And here's we've redlined or blue lined or whatever the difference is. You know, or a person responding to the subpoena that requires the production of documents shall produce them as they've kept in the ordinary course of business, or shall organize and label them to correspond to the categories. Essentially the same as the federal rule. Same here, just, I don't know, change must to shall. Any experts on language that can tell me the difference between must and shall? No, I honestly don't know the difference. So I would say we're dealing with the federal rule. You shall produce it. Motions to compel, this is a little bit different, but as a practical matter, again, this is just procedural. The person responding may object to discovery of inaccessible information. The objection shall specify the reason that it's inaccessible. On motion to compel, claims of inaccessibility, you bear the burden of showing it. If the showing is made, the court nonetheless orders discovery. This is very similar, obviously, to the inaccessibility rule under 26 dealing with parties. Just keep in mind, this is under Rule 45. So if your client gets a Rule 45 subpoena, you need to know the rules so that you can make the correct objections according, under the inaccessibility rule of 45D. And then again, dealing with subpoenas, we also have privilege protection. And it's the same type of issue. A person withholding information or claim of privilege is subject to protection, blah, blah, blah. Shall make the claim expressly, provide information that will enable the parties to assess the claim. That's kind of important, right? If my client gets a subpoena and I think it calls for attorney-client privileged information, I have the burden of clearly making the claim and explaining or providing information that makes it clear to the other side. I don't have to disclose the information, but like in the federal system, I have to disclose enough of the information so the other side can reasonably determine that I'm being straightforward with them and that this information really is privileged. I think it's interesting that they added a privilege law need not be prepared. That's critical. A little different than federal court, although again, we're dealing with Rule 45 here, not Rule 26. So it essentially says if you're a third party getting a subpoena, you have the burden of showing the information is privileged. You don't have that extra burden of having to put together a privilege law. So that's some relief and I think that it gives some comfort, aid and comfort to true third parties. What about further protections? This is entirely new and it's not in the federal rule. Any person subject to a subpoena may move the court for a protective order or to be deemed entitled to any protection set forth in any discovery or procedural order previously entered in the case. For those of you who've done a lot of third-party practice, this is sort of important. It's always been this issue when you get a subpoena. Do I have to object? If I object, do I have to go to court and get a protective order? And we were kind of dealing with these different rules. Maybe you have to object, maybe just objecting to the documents is enough, but then before the deposition is supposed to happen, do I have to get a protective order? And we'd always have these fights between counsel. You have to go to court, no, you have to go to court. This makes it pretty clear that the person who got the subpoena is entitled to go to court. And it was always a little bit of an unknown because you weren't a party to the case, right? Even styling your motion with the court was difficult. Third party corporation X hereby moves or something. This tells you, as a rules matter, you have the right as a third party subpoena recipient, a Rule 45 subpoena recipient. This gives you the right to go to court if you so choose in battle. And I think that's important and it makes it very clear. Okay, back to document responses. The new Mass rule tracks the existing federal rule. Here's the key. What really changed in the federal system in 2006? The federal rule said that ESI was discoverable, and that Rule 34 included ESI. It sounds minor, but it was a sea change, because it meant that the baseline discovery included ESI, and now we're there in Massachusetts. The baseline discovery of documents in Massachusetts includes ESI. You can object to it and object to the form, but just like the federal rule, if you request the form, the party shall state the form or forms it intends to use. So this puts the burden on the parties. If you're requesting data in Massachusetts State Court after January 1 under Rule 34, you have the burden. The requesting party has the burden of saying what format you want to see that data in. And if you say nothing, and we see a lot of this, if you say nothing, then the party responding gets to choose a format that's reasonable. Okay? That's kind of important because you want to choose, if you want a specific form of information, the data in a specific form, you better ask for it. Now, if you do ask for it in a specific form, the responding party gets to object. Okay? And if I object, I don't just get to object and say I'm not doing it. I have to object and I have to tell you what I do intend to do. What format do I intend to produce the data in? Maybe we end up in a fight and end up in court, maybe we don't. But at least there's a mechanism here to say it's got to be requested a certain way, and if it is, it has to be objected, and you have to tell me what you're going to do. None of this should really matter if we follow Rule 16. If we had that Rule 16 conference and had a plan, and the plan renders an order, then this rule shouldn't make any difference because we've already decided what format and what form the data will be produced in. But this will come up where there's not a plan or where there's a change in circumstances, the case moves on. 34C adopts the federal rule without changes, which just says, the procedures apply to ESI. A party shall produce them in the usual course and shall organize them. This is a cut and paste of the federal rule. I'm not going to spend a lot of time on it. The key to all this is, again, ESI is part of the mix. It's a baseline assumption that you're going to produce ESI in any document request, any document response under Rule 34. And if you don't like it, you better object to it. Let's talk about sanctions. We like sanctions, right? We heard all about sanctions just in the last panel. And I liked the way the prior panel framed this issue because this rule is the same rule as the federal rule. It's always bothered me. You read it and people call it a safe harbor. I think the vendors started that phrase early on. Safe harbor, it's a safe harbor. Let's read the rule. I think this is worth spending a little bit of time on because I think there's a trap here and there's no safe harbor. Absent exceptional circumstances, a court may not impose sanctions on a party for failing to produce ESI lost as a result of the routine good faith operation of an electronic information system. Let's parse that. Who the heck is sanctioning anybody for this? Okay? There's no case. There's no reason to keep it. I've got a document or a data retention policy that says after a year or 3 years or 30 days, whatever I want, ESI gets destroyed. The ESI is destroyed in good faith under the policy. Again, there's no preservation duty attached. Why would I ever be sanctioned for that? And I like how absent exceptional, I can't even think of an exceptional circumstance where a court would sanction a party for basically conducting its business the way it's supposed to conduct it. This is not a safe harbor. This is, to me, this is just verbiage. It doesn't even need to be there. It's noise because the issue isn't before litigation. The issue is when does my preservation obligation attach? And as we heard from the judges, it's when I reasonably anticipate litigation. Once I reasonably anticipate litigation, Rule 37F is irrelevant. Okay? Takes us out of the orbit of 37F. So I don't think this is a safe harbor. I think it's a misnomer, and I think it lulls attorneys, practicing attorneys, into a sense that as long as they have a data retention system or a data destruction system and it's operating, that they're safe. They're not. When you are reasonably on notice that there is anticipated litigation, you have to turn off that destruction system. This will not protect you. This doesn't, I don't know what this protects you from, but I guess if someone made the argument that you should have known something ahead of time, you could use 37F, but I don't think it's a safe harbor. I'm not gonna harp on it anymore, but I gave the same presentation on the federal rules. I've been saying it for 7 years, and I'll say it here. Don't rely on 37F. 37F has nothing to do with litigation, because once that preservation obligation attaches, 37F is inapplicable. This is a shameless plug for the new book, and it's actually 2013 edition. What I will say, and I want to leave time for questions because I know many of you said you wanted to stick around for this presentation. This has been a long process in Massachusetts. Okay, it's been years since these rules have been percolating. We had a very long delay over the metadata issue. When we first put this volume out in the spring of 2012, we were originally holding it because we thought the new rules, mass rules, would be out, and they weren't. And then a year later, it's the spring of 2013, and we find that we're still holding the new publication, hoping the new rules will come out, and they weren't coming out. And the summer slipped by, and we still didn't have a ruling. And that's why Chris Burek is such a saint, because she put up with multiple calls from myself and Judge Botsford and Judge Laurie. When are we going to see the rules? Because the bar, at least parts of the bar, were completely uncertain. And we finally get the final vote sometime in September, and we get the press release from the SJC, and the 2013 edition went out beginning of October, and we managed to incorporate the new rules. So it's probably the only guide out there that was prepared when the new rules came out. But here's the important thing. January 1, these new rules take effect. Maybe it's not a shock to the people sitting in this room, because people who voluntarily show up at an ESI conference are certifiably insane by definition, but put that aside, obviously have some interest in the topic. I think the vast majority, if not super majority, of litigants in attorneys in Massachusetts have no idea this is coming. I can tell you most of the judges don't have any idea this is coming. We're doing a program with Flashner to educate the judiciary, and we had to move it to the spring because we couldn't generate enough interest in October, November ahead of the rules change. Because judges, I'm starting to figure out, are just regular human beings, and there's no reason to do something now that I can put off for 6 months. So, what's going to happen come January 1, I think it's going to be a shock to the judiciary in terms of the issues that are in front of them. I think it's going to be a shock to a lot of practicing lawyers when they start getting requests for Rule 16 conferences, and it's going to get a little bit ugly. So, with that being said, anybody in this room obviously is ahead of the curve. I really, really encourage you to read the rules. If you don't have a copy, on the Nixon Peabody table, there's an alert that has the rules attached. Take a copy, or just go online and get them. But read the rules, be prepared, because after January 1, that is the state of Massachusetts procedural law, and it's only about 3 weeks away. So with that, I'll open it up for questions. Yep.
On that so-called safe harbor thing, I remember back when the feds came in with it, there was some fear, and there were some instances where a recycling process destroyed a year after they were made or overwrote some entries. And the argument was, well, so what? You should interfere immediately when you know there is a claim, or it was kind of amorphous. So I think the LCJ, some of the defense groups wanted a lot broader safe harbor, and all they got was this, which they felt was better than nothing. Now, then we looked at the federal rules. Well, okay, we'll adopt it too. We didn't think it was the greatest thing since inside plumbing, but we might as well have it, because it's possible that someone would say immediately when someone is angry at you, you got to stop all good faith, you're not trying to destroy anything, that you're gonna get defense.
Yeah, no, I agree, and I have very strong opinions about some of this, including inside plumbing. But I guess what I would say is I think that lawyers hear safe harbor, and in their mind, they think I don't have to worry about the auto retention or auto destruction system. And I'm just trying to get through to everybody that once you're on notice of litigation, whatever the preservation obligation standard is, once it attaches, okay, I'll leave that substantive issue aside for a minute. Once the preservation obligation has attached, Rule 37F no longer applies. So you just have to be aware of that.
It's not a safe harbor at all.
And you know what, in fairness, neither the feds or anyone else ever called it a safe
No one
harbor.
ever called.
Yeah, but it developed that reputation, and I think it was a vendor issue, and then all of a sudden everyone talks about the safe harbor under 37F. So it's not. Yeah.
When I was up on the panel fumbling around with sanctions for the first time in about 5 years, I think I heard Judge Rutherford mention something about the new rules allow judges to issue orders on the ESI sponte, and talked about how unique that was compared to any other state rules or federal rules. Do you have any more insight into that?
I mean, and again, maybe I'm old fashioned. I mean, judges can pretty much do what they want to do, right? I mean, I've been in front of many judges, and you know, the word sponte, I mean, all of a sudden you're talking about an issue you had never an intention of talking about. And I've certainly been in front of state court judges who have brought this stuff up. I don't think, and you know, someone correct me if you think I'm wrong, I think if judges wanted to raise ESI issues, you know, sponte prior to the new rules, I think they could, and they certainly were. And they were in some cases I was involved in. We have a situation, I won't, by the time it comes up here, I won't bother, but my associate Ronaldo Rosario over there, you know, he had a situation in land court where the judge just recently said, about a month ago, gee, I like these new rules. You know, I'll tell you what, let's pretend they're in place and we're gonna live by them in this case. And it's created a little bit of chaos in the case. To me, that's sponte, right? The rules aren't in place, and yet the new rules aren't in place, and yet he is ordering the parties to conduct themselves in a certain way. So I don't view it as that big of a deal. I mean, I think judges always felt if there's an issue in the case that the parties, the lawyers aren't raising and feel it's important, many judges always felt I should raise this, and you see that a lot. So I don't think it's that big of a deal, but it is obviously. If a judge is interested in it, they'll hang their hat on that provision to say, I'm raising this under that rule.
Rule 34C1 allows you to produce documents in the manner in which they're usually kept in business. How does that apply to ESI? If you're a large organization with lots of locations, lots of people create documents, and you want to collect them all?
I mean, the way we've dealt with under the federal rules typically, because paper's easy, right? It's in a file cabinet, you copy the file cabinet. In the ESI world, we've traditionally said the way it's maintained, usually we think about native format. You know, you have a document, you have a Microsoft Word document, it's maintained as a Microsoft Word document, you can produce it natively. It's probably the cheapest way to do a production, it's probably the most dangerous way to do a production in terms of metadata issues and other things. So the concept under the federal rules were you could almost always produce it in native format and be safe, but what most parties like to do was to produce, you know, searchable PDFs with some metadata fields. And the trick there is you're gonna start having conversations with the other side about what fields am I gonna produce, and if we can't agree, what's reasonable, and you get into that whole issue. But in small cases, I mean, we would oftentimes just do a native production. It's the cheapest way, it's clearly allowed under the rules, it's the way the data is kept in the usual course. But if you've got something that's a little larger or more complex, or you have concerns about metadata, it's not a very safe way to do it.
I think we all understand about litigation holds and explaining them to our clients and explaining to the IT department that they have to shut off the automatic completion functions. Can you talk a little bit about, in your normal practice, what you do after the case is over and the litigation hold should be removed? There was an article in Lawyers Weekly this week about ExxonMobil over-preserving.
Well, my case has never ended, so I've never dealt with it. Just kidding. That's actually a really good question and a really important topic. And you know, the danger is, and this happens all the time, you've got a large case, you've got all this data you've preserved. It happens a lot in the pharmaceutical context as well. And what you end up with is this giant corpus of data, and you may have just defended a claim by the government or a claim by an individual plaintiff. And now you may be aware there could be follow-on suits. There could be a follow-on civil suit to the government investigation. There could be a follow-on, another individual. There could be a follow-on class action. And companies are rightly scared. They'd love to flush this data, but they fear that if they do that and they use the indoor plumbing, then what's going to happen is the next plaintiff coming along is going to say, you knew I was out there. You knew I had the same injuries, and you didn't keep the data you had, and I'm going to sanction you. So it's a really, really difficult issue. There's no easy way. There's no easy explanation. I think for practical purposes, once you're sure that there are no more claims and it's done, you can get rid of it. But most companies, as a practical matter, still hold on to that data for a period of time, whether it's a year or 18 months or something else. And the difference is it's a little less costly to maintain it because you're not having it online. You can store it on hard drives. You can do other things with it. But you just probably want to make sure you preserve it, because the last thing you want is a claim of spoliation after you've spent all the money collecting and preserving this for 10 years, and then the day after I dump it, there's a claim. Anyone else? We have time for one more question, I was told. And look, there's no more questions. Perfect. Well, folks, thank you. I appreciate it. I know it's a lot. It is a lot of information in a short amount of time. I would just encourage you to make sure you're ready on January 1. Thanks, folks.